Registered representatives offer securities through Independent Financial Group LLC, IFG, member FINRA SIPC. Investment advisor representatives offer advisory services through Independent Financial Group LLC, IFG, a registered investment advisor. Cornerstone Wealth Management, Cooper Coons, and IFG are unaffiliated entities. The information and opinions presented are for general information only and are not intended to provide specific advice or recommendations for any individual. You should contact your investment representative, attorney, accountant, or tax advisor with regard to your individual situation. The opinions of the presenter do not necessarily reflect those of Independent Financial Group LLC, its affiliates, officers, or directors.
If you're nearing retirement or worried if what you've saved is going to last, then this is the podcast for you. Now let's join Cornerstone co-founder Jamie Avila for the Cornerstone Retirement Blueprint Podcast.
Welcome, everybody. This is Jamie Avila, managing partner of Cornerstone Wealth Management. Here with you today, we have a great guest. Our topic today is going to be on estate planning, and we actually have one of our partners here at Cornerstone, Jeremy Cooper from Cooper Coons. In fact, Jeremy, before we get into some of the questions, tell us a little bit about yourself, your firm, and kind of what you specialize in. I know different attorneys in estate planning focus on different things, but tell us a little bit about what you're doing over there at Cooper Coons.
Sure. Thanks. Thanks for having me here on the podcast. Like I was saying, this is the first time I've ever done one of these, so it's an interesting experience. Hopefully it goes well, but we'll see about that. So anyways, I'm an estate planning attorney. That's pretty much all I've ever done as an attorney. I've been practicing for about 12, 13, maybe going on 14 years now. And the entire time I've worked in this area, it's been focused almost entirely on estate planning, asset protection, probate, trust administration, and planning items along those lines, as well as we do some just transactional work for small business owners, contract review, we'll do buy-sell agreements, things of that nature as well. I'm a CPA also. I did a few years with PricewaterhouseCoopers in the Bay Area out of school and got that background in tax accounting, which proved to be very useful in my area of law because, as I'm sure you know, estate planning isn't just drafting wills and trusts. It involves dealing with taxation and issues that relate to taxation almost on a daily basis, especially these last few years.
Absolutely. You know, and I think that's something to point out to our listeners is that some attorneys in town, they do it kind of on the side, right?
Right.
They have a practice. They may be personal injury, but they do living trusts and wills and stuff. And your practice primarily focuses on just estate planning with business planning as well.
Yeah, that's correct. And so you do see a lot of attorneys who they'll get their hands on a good form that for a trust or a will, and on a basic level, maybe that's okay if it's a very simple setup. But I found that there aren't very many simple setups. People think they may have a simple estate to deal with, but it doesn't really take much for different tax issues or just kind of complicated estate planning issues to come into play.
Yeah, and so one of the other things that we get a lot of questions about when clients come in is they just want to know what's the difference between a will and a trust, and how do I know what I need?
Yeah, so that's really a very common question. We hear it all the time, and the main difference is with a will, you tell us who gets what when you die, which is important. We want that to be documented in a legally enforceable manner. But there's a common misconception out there that if you have a will, that avoids the process of probate. And if you've been through a probate before, if you know what probate is, it's generally something you want to avoid. It's a court process that you have to go through if you pass away to transfer your assets out of your name into the names of your heirs or the beneficiaries you name in a will. And so the bottom line is, while a will is helpful in telling us who gets what, it doesn't allow for probate avoidance in and of itself. That's where the trust comes into play. The trust is the mechanism that will generally use to avoid probate. And that saves a lot of time and money if you have one of those in place.
By the way, I know different states are different, but how long for probate in the state of Nevada, and what does it typically cost?
Yeah, so there's different levels of probate. On a very basic level, it doesn't actually take that long, and it's maybe not that bad, but that would mean your estate has to be really worth less than $100,000. And that's maybe a 6, 7, 8 week process at most. But most people who pass away, if you have a home, especially in this town, you're usually above that $100,000 threshold. Most homes are just more valuable than that. And so you're doing a more advanced version of probate. You're looking at minimum 6 months, probably closer to 8, maybe even a year.
Okay.
And thousands of dollars. We don't mind doing probates because they're fairly lucrative as far as attorney's fees go. But it's our goal to make sure none of our clients ever go through probate because it's just a literal waste of time and money.
Okay, so for a person who has a smaller estate, they probably are going to be okay with the will, but anything over above maybe 1, 2, 3, 400, 500,000, or if they own a property, probably want to have a trust so that they don't end up in probate court.
Correct. Yeah.
Okay.
That's the general approach. Even with smaller estates, depending on what they're trying to accomplish, sometimes a trust will still make sense.
Okay, good. And then occasionally we'll have clients in here that are higher net worth, and so they'll ask, well, do I need anything else other than a revocable trust?
Right.
And so what do you say to that?
That's an excellent question, and especially that's a timely question given the way things have been lately with the potential change in our tax laws. And so there's always advanced planning that can be done from a taxation standpoint. When I'm talking about taxes in this context, I'm referring primarily to the estate tax, or what most people might refer to as the death tax, which is the tax that is incurred just basically upon your death for the privilege of having died.
What is that starting at right now?
So right now, if your estate, we have actually pretty favorable laws in place currently because they didn't change. We thought they were going to change. I'm actually frankly surprised they didn't. And as you probably know, over the last couple of years, there's been multiple proposals trying to increase what we call the lifetime exemption, meaning the amount you can die with before you're subject to the estate tax.
Which right now is about 11?
So now it's gone up this year. It's been increased with inflation to $12 million per person. So with married couples, you can exempt up to $24 million, which means hardly anyone is having to pay that tax, which is great from an overall, effective tax rate standpoint. But there are people who do fall into that category, and as I've learned over even the last couple of years, a lot more than I probably even thought there were out there. And so if you do fall into that category and you have assets that exceed that $24 million mark as a married couple, then you're looking at a potential 35 to 40% tax rate on anything above and beyond that, assuming you're not giving it away to charity.
What's crazy, Jeremy, is I remember when I first got into the business in '98, I remember the exemption was $600,000.
Yeah.
And so 1.2 million if you're married, and it was like 55%.
Right.
And so, you can almost feel it in the air right now in Washington that something, with all this debt we're carrying, at some point there's going to be a money grab.
Right.
And they're probably going to lower that threshold from 12 million. I know the proposed legislation, wasn't it like 2.5 or 3 million?
I think the most recent one that I saw, and it changed often, so until they actually pass something, I just kind of monitor it. And I think the most recent I saw was it was going to be about 5 million, which isn't too bad, but it still is a lot less than 12 million, right? Or 11.7, which is what it was last year. But you're right, it's gone up quite a bit, the exemption that is, over even since I've been practicing. So it's
going to be interesting to see what direction they go for that money.
No, I think you're absolutely right. We've just been spending too much money for them not to do some form of reform. I don't know that it'll happen this year because it's an election year.
Oh, it's election year, yeah.
Right. So we'll see, though.
Yeah.
Who knows?
Yeah, that's interesting. So from a client standpoint, when they're higher net worth, what are some of the things that you're kind of presenting to them that, and we can go high level, we don't have to get into the weeds, but just to kind of give our listeners an idea on what direction you may be going.
Yeah, I think that was your original question, and I went off on a tangent. And so that's a great question as well. So typically the most popular approach is we'll set up irrevocable trust that clients will gift assets into. And when you gift the assets into these trusts, you use up some of your $12 billion exemption. But the idea is that the assets you put into these trusts, as they appreciate, whatever that appreciation is, including obviously the assets themselves, avoid estate tax upon your death. And so that's a very common tool that we'll use. It allows the clients in a lot of cases to actually retain control of these assets while they're in these trusts. And you can even have with married couples, one spouse set one up for another, and possibly even have the other one do it for these other spouse as well, as long as you do it correctly. But that's the general approach that most clients are taking, is they'll gift assets into these irrevocable trusts. And then some of them will also do some charitable planning, charitable remainder trusts, and private foundations, things of that nature.
But
as
like
well.
you said, on the ILET or the irrevocable trust you mentioned, you still can maintain some control.
It depends. Yeah, you want to do it correctly. Typically, you can set it up to where maybe like one spouse will set up what we call a spousal lifetime access trust. And so you'll have, like, we'll just say as an example, a wife maybe will set up a trust like this for her husband as the beneficiary. And if you structure the trustee's powers correctly and the distribution provisions correctly, you could have it to where the husband actually is a trustee of that trust.
That's interesting, because most people, when they end up having to do types of planning, they're having to give up control.
Right.
And, their kind of hands are tied, and they really have to trust somebody that they put in there.
Yep.
And so that's kind of interesting. What about anything new with asset protection trust? We hear a lot about it. I know probably 15 years ago, I heard about the Nevada onshore asset protection trust.
Right.
Is that still applicable today? It
is.
Okay.
Yeah, and it probably was about 15 years ago. Nevada was, I think, maybe the third state who passed laws that would allow people to set up a trust that they could control as a trustee and actually be a beneficiary of it. And as long as it's set up properly and maintained properly, and 2 years have passed from the time you fund it, the assets are protected really from lawsuits. Bankruptcy is kind of questionable as to when that protection kicks in. That, I think most people are thinking that's more like a 10-year waiting period. But they were, our state, that is Nevada, was at the forefront of trying to push these types of trusts. We call them self-settled spendthrift trusts as well. That's the technical term. But Nevada Onshore Trust or Nevada Asset Protection Trust are other terms we'll use to label them. But I do a fair amount of those, because, as I tell clients all the time, you don't have to drive too far in this town to see that every billboard, I used to say every other, but I think it's pretty much every billboard now is for a personal injury attorney.
Absolutely,
And so we're just in a litigious society. You can't have almost too much protection, in my opinion. I don't want to necessarily scare people into thinking they need this, because in most cases, people have umbrella policies, they have auto insurance policies, they have homeowners policies, which are always going to be what I call the first line of defense in a litigation matter. That's typically what attorneys will want to access in order to settle. And it's rare, but it's not unheard of, that you'll actually have an attorney go after your personal assets. It does happen.
Right.
And that's when an asset protection trust will come into play, because you can put investment accounts, real estate, rental properties, investment properties into a trust like this that would not have the type of protection these trusts offer otherwise.
Yeah. And is there typically like a seasoning period where you have to have the assets in the trust for a certain amount of time?
So Nevada's statutory seasoning period is 2 years, and that's on a asset per asset basis. So it's from the time you move the assets into the trust. It's not from the time you actually set up the trust, and that's important to remember.
So what type of clients are actually putting together an asset protection trust? Like, what's the profile?
Yeah, that's another common question I'll get, and it really depends. It comes down to, if you have assets that you want to protect and you feel you need that protection and are willing to pay the legal fees to set it up, then you really fall into that category. And so I've had a range of clients who want to do them. Primarily, they're clients, who would fall into the category of maybe being not even necessarily high net worth, but just maybe someone who has a couple rental properties, an investment account or two. But I've even had people who just have one rental property, and that's their main asset that they want to protect, for lack of a better term, at all costs. And so we have set up trusts like that for people in that situation as well. They're relatively easy to maintain once you set them up. You don't have to file tax returns for them.
Okay.
And so that cuts down on the administrative burden that comes along with it. But there are things that you would want to be aware of in terms of how you access the assets once you move them into the trust. And so clients need to make sure they understand that and are comfortable with that.
Absolutely. And then I've heard of clients, you mentioned rental homes, and we have a lot of clients that have rental homes.
Right.
They'll just have like an LLC in there, or a series LLC. And so what's the main difference between that route that somebody goes versus
the asset protection trust?
Yeah.
Excellent question as well. And so LLCs are great. I use them all the time. And if the asset protection trust isn't a good fit for someone and they have a rental property, then I think the LLC is the next best option and should be in place, because it does provide that limited liability protection, and it also provides what we call charging order protection. But what that means is you kind of get protection from both angles, meaning if you have a tenant on a rental property sue you, if you have the property in an LLC, the idea is that it limits your personal liability, meaning they can't go after your personal assets. They can only go after the assets in the LLC. But it also works going the other direction, to where if you have a rental property and you get into a car accident just while you're out driving around on a Sunday afternoon and you get sued, and someone wants to go after your personal assets and you have your rental property in an LLC, our law here says that the sole legal remedy available to someone in that context is a charging order, meaning they can't take the LLC from you, they can't take the assets in the LLC from you, they can't force you to liquidate the LLC to pay off a judgment that they have against you. All they can do is intercept profit distributions made from the LLC.
So like income that
correct. Right. And so that's really, I think, where the main difference between an LLC and an asset protection trust comes into play, because with an asset protection trust, they don't even have that legal remedy available to them. The assets in the trust are completely sealed off from creditor attack, if you will. Yeah, it is. It's a nice tool.
Like, Jeremy, you're the man that protects the retirement plan, right?
Yeah, and that's a good point too. We have statutory protections in place for qualified retirement plans, in addition to other assets outside of that realm. So that's that. I guess you could say that I'm that guy.
Yeah, well, that's cool. Well, I can tell you that in all the referrals that we've given you from our firm, everybody has had a positive experience, and so that's tough in this day and age, because we have referred our clients to lots of different estate planning attorneys in town the last decade.
Right.
And I can't say that, you know, and they say you're responsive, you're very knowledgeable, and which, we can tell just from talking with you. And so you're doing a great service to the people here in Nevada.
That's a high compliment, and I appreciate it very much. I appreciate the people you've sent my way. I can honestly say they're some of my favorite clients. They have been great to work with, and you guys have been really good about pushing people kind of in the right direction to do the planning, I think, at a time when it makes sense. And there are a lot of guys out there like me doing this, and so I know you have options, and so it means a lot that you look my way when you're sending people over.
Well, listen, if you're listening and you're like, look, I may need to look at getting a living trust or a will or something, or I may need some advanced planning, whether it's an asset protection trust, whether it's a CRT, whatever it is, give our office a call, and we'll coordinate a meeting with Jeremy, and they'll be able to get the Cornerstone discount, right?
Oh, yeah, for sure. And we do a complimentary initial consult, so feel free to come over, just chat me up, see what you've got, and if I can help, and if not, no big deal.
Awesome. Well, appreciate you being here. Thanks for sharing just a little bit of your time with us today.
Absolutely.
And we look forward to sharing some of our other clients that definitely are in need and some of the services you provide.
Well, thank you. It's been fun. I've enjoyed it. It was actually pretty nice. So.
Awesome. Well, cool, Jeremy. We'll look forward to having you back.
Absolutely.
Thanks.
Securities offered through Independent Financial Group, LLC. IFG. Member FINRA SIPC. Cornerstone Wealth Management and IFG are unaffiliated entities. The information and opinions presented are for general information only and are not intended to provide specific advice or recommendations for any individual. You should contact your investment representative, attorney, accountant, or tax advisor with regard to your individual situation. The opinions of the presenter do not necessarily reflect those of Independent Financial Group LLC, its affiliates, officers, or directors.